Hello and welcome to Law Kanya. In this series of quotes this week, I tell you about the legal developments that took place in the country in the previous week, starting off with the Supreme Court judgments first. In this case, Supreme Court acquitted a man accused of raping a woman on the pretext of marriage. Observe that misconception of facts arising out of promise to marry has to be in proximity of time to the occurrence and cannot be spread over a long period of time coupled with a conscious positive action not to protest. The allegation by the prosecutrix in this case was that the accused Maheshwar Tigga has been promising to marry her on the pretext of continuing to establish physical relations with her as husband and wife. It was also alleged that she has also stayed at his house for 15 days, during which also he established physical relations. The trial court convicted him under sections 376, 323 and 341 of the Indian Penal Code. The Karnataka High Court dismissed his appeal. While considering his appeal, the bench comprising Justices Rohinton Fali Nariman, Navin Sinha and Indira Banerjee noted that in this case, the accused belonged to scheduled tribe, while the prosecutress belonged to Christian community. The court also said that the letters between them, which were produced as exhibits, make it appear that they love each other. Also, in the same case, the Supreme Court has observed that the circumstances not to put an accused under section 313 of the CRPC cannot be used against him and must be excluded from consideration. In this case, Supreme Court reiterated its judgment and said that there cannot be an inherent right to compassionate employment. A three-judge bench observed that the compassionate appointments had to be in terms of the applicable policies as existing on the date of demise, unless a subsequent policy is made applicable retrospectively. The court allowed an appeal filed by the state of Madhya Pradesh against the High Court judgment, which had directed it to grant compassionate employment to the son of an employee who was the working driver in the Tribal Welfare Department. The state in its appeal contended that the employee was employed as a work charged or a contingency employee in the Tribal Welfare Department and was thus not entitled to compassionate appointment as per the existing policies on the date of his demise. In this case, Supreme Court has observed that the transfer of criminal cases cannot be ordered under section 406 of the CRPC on ground of lack of territorial jurisdiction even before evidence is marshalled. In this case, the length of sentence or the gravity of principal origin crime cannot be the sole basis for refusing premature release, the Supreme Court observed while directing release of two convicts on probation. The three-judge bench observed that any assessment regarding the predilection to commit crime upon release must be based on antecedents as well as conduct of the prisoner while he was in jail, and not merely on his age or apprehensions of victims and witnesses. Taking note of these grounds of rejecting plea for the premature release, the bench observed that the three factors of evaluation, that is, antecedents, conduct during incarceration, and likelihood to abstain from crime under Section 2 of the UP Prisoners Release and Probation Act have been given a complete gobi. We all know that a special bench court at Lucknow on Wednesday acquitted all 32 persons accused of hatching a criminal conspiracy behind the demolition of the Babri Masjid Mosque on December 6, 1992. It is indeed a landmark. The acquitted persons include prominent BJP leaders L.K. Advani, Murli Manohar Joshi, Uma Bharti, Kalyan Singh and others. Special CBI Judge S.K. Yadav, in his 2,300-page verdict written in Hindi, held that the demolition of the mosque was not premeditated and that there was no criminal conspiracy behind it. The court said that the demolition was not pre-planned. The court further observed that such a group of people cannot be called anarchist, and they could not certainly be called Ram Bhakts, as they were bent on to demolish disputed structure, and that the Supreme Court had made the aforesaid observation, that is, the destruction of mosque and the obliteration of the Islamic culture was an egregious violation of the rule of law. In this case, Supreme Court has observed that it is not necessary that an accused must be actively involved in the physical activity of assault and convict him on the grounds of common intention. A common intention to bring about a particular arrest may also develop on spot as between a number of persons deductible from the facts and circumstances of a particular case. The court was considering the appeal filed by a three accused convict in a murder case. One of the accused contended that he could not be said to have shared any common intention with the other accused, who were liable of their individual acts. The Supreme Court, in its judgment quashing Gujarat government notification extending the work hours under Factory Act without overtime pay, has discussed constitutional provisions about public emergency and security in state. The court noticed that Article 352 of the Constitution, prior to its 44th Amendment, which reads as follows: if the President is satisfied that a grave emergency exists whereby the security of India or any part of the territory whereof is threatened, whether by war or external aggression or internal disturbance, he may by proclamation declare it to an effect. The financier continues to be the owner of the goods being subject of hire purchase until the option to purchase is exercised by the hirer, upon the payment of all amounts agreed upon between the hirer and the financier. The Supreme Court has reiterated in a judgment passed on Thursday. The bench comprising Justice D.Y. Chandrachud and Indira Banerjee observed that there is no impediment to the financier taking possession of the vehicle when the hirer does not make payment or installments in terms of the hire purchase agreement. The bench was considering an appeal against the National Consumer Disputes Redressal Commission order. In this case, the Commission upheld District Forum's order directing the financier to pay the entire amount by the complainant to the financier towards installment. Now let's move to High Court judgments. The Bombay High Court has asked that it is mandatory that the requisition for a special meeting to move motion of no confidence against the chairman or deputy chairman is either hand-delivered or posted through a registered post to the collector. It is the collector under subsection 3 of section 72 of the Maharashtra Zilla Parishads and Panchayat Samitis Act, therein who has to call a meeting within 7 days from the date of requisition, the court observed. In this case, a significant judgment rendered on September 22nd, the Delhi High Court has discussed in detail the legislative intent and applicability of reverse burden under Section 29 of the Protection of Children from Sexual Offences Act 2012. The single bench judge of Justice Anup Jairam Bhambani, while considering a bail application of a 24-year-old man accused of coercing a 17-year-old girl to have sexual intercourse with him, at the threat of publicizing her private pictures taken against her consent. Whereas the bail applicant had contended that he should be enlarged on bail since the investigation is complete and the charge sheet is the matter has been filed, the prosecution has released and the application of POSCO to consent bill. In this case, Delhi High Court has granted bail to a person accused of sections 20 and 29 of the NDPS Act by noting the prosecution failed to show any medical evidence to support its narrative that the accused is a drug addict. While granting bail, the single judge bench of Justice Vibhu Bakaru further observed that there are reasonable grounds to believe that the accused might be acquitted of offence that he is charged with. In the present matter, a bail application was moved by the accused person, who was arrested by the Narcotics Control Bureau for allegedly smuggling and dealing with the commercial quantity of charas. While quashing an order of detention passed under Conservation of Foreign Exchange and Preventive of Smuggling Activities Act, the Bombay High Court held that the purpose of detention order issue under the Act is to prevent the detainee from indulging in prejudicial activities like smuggling, and if there is a unreasonable delay in making of the detention order, it becomes vulnerable. If the delay is not satisfactorily explained, that itself is a ground to quash the order of detention. Division Bench of Justice S.S. Shinde and M.S. Karnik heard the criminal writ petition filed by a 40-year-old Suresh Jaiswal, who arrested after the electronic goods worth more than 4 crore on September 4, 2019, under Section 110 of the Customs Act on reasonable belief that the same is liable to be confiscated under the Act. The detention order was passed on February 14 this year. Now, in this case, the Bombay High Court ordered a thorough inquiry into allegations of demand of bribe against jail authorities for granting emergency parole, which they write as per the state government's notification dated May 8, after being informed that over 130 applications seeking emergency parole are pending. Division Bench of Justice Stevie Nalware and Justice M.G. Shevlikar of the Aurangabad bench ordered that the petitioners in this case had approached the court in similar matter for similar directions, and the court had directed to decide the applications within 15 days. This was it for now. Thank you for watching my video. If you like my channel, please subscribe to it.